only 1 in 8 preventable medical errors actually ends up being pursued in a medical malpractice lawsuit. Some statistics are helpful in looking at medical malpractice lawsuits and the role that they play in the overall healthcare industry. The Journal of Patient Safety found that there are over 440,000 deaths each year in the United States from preventable medical errors. Harvard Medical School found that only 1 in 8 preventable medical errors results in a medical malpractice lawsuit. And they ended up doing a survey of medical malpractice lawsuits where they found that 97% of the cases they looked at in medical malpractice were meritorious. And they published those findings in the New England Journal of Medicine. The Congressional Budget Office analyzed all expenses related to medical malpractice litigation and determined that it accounts for 0.5% of expenditures in the healthcare industry. The National Practitioner Data Bank did a survey of medical malpractice payouts and found that 5.1% of doctors are responsible for over 50% of payouts in medical malpractice litigation. So hopefully these statistics end up showing a little bit about what is happening in medical malpractice and its role in healthcare, and also end up rebutting some misconceptions out there. When we get medical malpractice calls, we end up having to tell the overwhelming majority of them that we're not able to help them. It probably is along the lines of 97 to 99%. And that falls into several categories. One is just that people call with known medical complications from whatever procedure they ended up having. They may or may not have been told about the complications or the extent of them, but that ends up being something that we can't help them with. The trickier ones are the ones where it appears that there may have been a medical error involved, but because of the economics of medical malpractice litigation, it becomes difficult or impossible to pursue. Those can fall into several categories. One is when a patient makes a full recovery. When a patient makes a full recovery and you anticipate going before a jury a year to a year and a half down the road and have them talking about all the terrible things that happened in the past, but the juror is looking at someone who's doing quite well now. And it's very hard for potential clients to understand the difficulties in representing them. Where the economics come in is that the cases are very expensive to bring. A jury is not going to end up giving compensation to that person who made a full recovery the same way that they would give someone compensation who has an ongoing problem. But the expenses are the same. The largest expense is the fees that doctors charge because we have to hire medical doctors to review a case and give an opinion on whether or not there's medical malpractice. And that can end up being whether there's a medical error, whether it caused a damage, and then the extent of the damage. And there can be different medical experts for each one of those. Our expenses often can approach $50,000 for a case before we get to trial and can be double that when we go to trial. And that's for a regular case. For more extensive cases that require more experts, it can easily be double that, facing $100,000 before trial and $200,000 at trial. And that's why some economic cases just are too difficult to end up pursuing. For a more complex case that ends up requiring more experts, an example would be a brain trauma case. We just ended up handling a case where we ended up having to get an ENT doctor to opine on whether there was a medical error done in a sinus procedure, a neurologist to testify as to the extent of damages to the brain from this procedure, a neuropsychologist to do testing to quantify the damages, a vocational rehabilitation specialist to end up describing the difficulties that he incurs at work, and a professional economist to put together all the costs. That's an example of the case that's going to be on the higher end of medical costs in pursuing litigation. Another area that especially presents a challenge are elderly patients that either call us or have family members call us. The challenges that arise in those situations are that when they are at an advanced age that have lived past life tables, what many potential jurors may not have family members their age, the difficulty is severalfold. One is that they may not survive to a trial. So if the medical malpractice was something that they suffered, they may not be able to describe it at trial, and you end up having relatives saying, I wasn't hurt, it was my relative who you can't meet, but we'll try our best to describe it. And anything that separates jurors from the experience is not going to be good for the client and the potential for the case. Another one is that the older the potential client is, the more likely that they have other medical conditions going on. And those may affect how long that they would live, regardless of whether medical malpractice occurred. And that is something that the defense certainly points out, and it makes it difficult for cases because, again, jurors are thinking, yes, something may have been done wrong, but this family that lost their family member from malpractice probably wasn't going to have them that long. It doesn't make it any easier for the patient or the family to understand when you have to go over some of those harsh economics. And of course, those cases with the same expert witness cost the same as many of the other cases to bring, and yet you face those economic challenges. Categories of damages in medical malpractice are finite categories, and some have limitations on them. It is not a free and open lottery system. Everything has to be proven by the plaintiff. And in each category, for instance, a plaintiff has to show past medical bills and through doctor testimony show what future medical care may be needed through the expert doctors. They can get any past wages that they proved were caused by medical malpractice and any future inability to work. Another category is called pain and suffering damages. That is for the past and future, if it applies, if it's an ongoing injury, pain and suffering for having to go through the medical malpractice. And most states end up putting caps on those. In Maryland, we have a cap that started in 1986 at $350,000 that applies to all medical malpractice cases. Over the years, that's been increased to keep up with inflation. And currently, that number is $740,000 for cases that occur this year. That cap applies whether someone has a minor injury and makes a full recovery or if someone is a quadriplegic at a young age and is going to live a long time according to medical prognosis. So that same amount, there's no coming back at any time. That's $740,000. It applies to a horrible burn victim who has to go through more procedures than nearly any other medical malpractice victim. The caps are different for an individual and for a death case. If the individual pass away, Maryland law ends up providing that natural parents and natural children end up having a claim. Now, in Maryland, that cap is different if you are injured by medical malpractice than if you're injured in an auto accident or on someone's premises. If you're injured in an auto accident, the cap is $2 million. But if you're injured in medical malpractice, it's only slightly over $900,000. And that was a decision that the Maryland legislature made in 2005, that they were going to limit medical malpractice cases more than they were going to limit other types of injury cases. The rationale behind this is that with over half the states having caps now, you would hope that those caps would reduce, or the theory is that they reduce physician economic exposure through medical malpractice, that they would correspondingly get a reduction in malpractice premiums, and doctors would want to practice there. And if your state doesn't get those caps, you're going to lose doctors over to those states that do. Reality has not played that out. The states that have not implemented caps have over 20% higher per capita physician rate than the states with caps. They just simply have not done what was thought to be the effect. So as the patient bringing a medical malpractice lawsuit, we have the burden of proof. It means that from the very start, we do not end up getting to the jury unless we end up proving that medical malpractice occurred and that it caused injury in this case. And there are several components to that. The first one is that a doctor made a medical error that ended up being what's called a breach of the standard of care. The second component is that it caused the bad medical outcome that happened in this case. And then the last is the damages that ended up flowing from that. Now, in many cases, the causation is a given because there's a direct link and it's really not a battle. But there are some cases where causation is really difficult. And then sometimes the combination between the burden on the plaintiff of proving and things that can't be proven in science end up with real catastrophic results. We had one case that was just an absolute tragic case. A couple in their mid-30s decided that they were going to have another child, and the husband went in for a vasectomy reversal, which is about as basic of a procedure that you can expect to do. The physician who ended up doing the procedure walked back into the sterile operating room without following the sterile procedure and picked out instruments that he was going to use and then returned to the dressing area. We know this because a nurse had the courage to report him to the hospital, and he ended up having an incident report done because of it. The tragedy was that the nurse's courage occurred after the procedure and not before, and the procedure went forward. The patient ended up getting an infection at the site of the surgery that ended up resulting in necrotizing fasciitis that went to his brain and ended up causing permanent brain impairment, requiring him to have to live in a nursing home for the rest of his life. His wife came to us and said that her goal was to get enough compensation to be able to have home health care and bring her husband home to be able to live with the family. We ended up approaching medical experts to review the case. On the medical error, the breach of the standard of care, there was no problem. This was an absolute no-no, and that was not a challenge at all. Where the challenge was in proving the causation. We had to prove that when that doctor went in and touched the instruments and contaminated them, that contamination was what caused the infection. And we consulted with infectious disease doctors who ended up telling them, we asked the question, did what this doctor did, can that cause what happened here? Definitely. Did it cause what happened here? Maybe. And that's not good enough. We have to have probably. And the reason is that infections like that, although rare, can happen from other sources. And that's an example of where the burden of proof on plaintiffs and what can't be proven in science takes a tragic medical error and really just leaves the family without any recourse. One of the things we hear from a lot of patients is complaints about communication with doctors that often fall into a couple of categories. One is lack of time spent with doctors, and another is the lack of quality of the communication when they do get to spend time with doctors. Often patients will report to us that they feel like questions aren't welcome and that they are merely being seen by the doctor in a way to maximize the doctor's office efficiency, have them lined up in offices as almost like an assembly line, go from one room to another, taking care of issues in the least amount of time that's necessary. And the same in the operating room, an assembly line lined up according to whatever time is allotted by the doctor, and then move those patients out to recovery afterwards. Not surprisingly, when you end up trying to maximize time efficiencies, there is evidence that corners are cut. There was a very interesting article by a Hopkins doctor in the Journal of American Medical Association, who ended up looking at the effect of videotape in the provision of health care. And he looked at a couple of studies. One was a New York hospital that was having, of all things, difficulty having its medical providers washing their hands. They kept seeing evidence that they were not doing that, and that was a basic thing that had to be done to fend off infection. They ended up making it known that the wash stations were videotaped, and the compliance rate went from 6% to over 80% when the employees, healthcare providers, nurses and doctors knew that it would be videotaped whether or not they end up washing their hands. Another study cited by this doctor had to do with doctors that were doing colonoscopies. The equipment itself is set up so that the procedure can be recorded. The screen of what the doctor is looking at can be saved to videotape. So one medical provider decided that they were going to do that with certain colonoscopies and let those doctors know that they were going to be recorded, and then do it with other doctors and not let them know that it was going to be recorded. The doctors who had their colonoscopies recorded spent 49% longer looking during the procedure, and the quality was evaluated of the assessment of the different things encountered, and that quality was determined to be 31% better in the colonoscopies that were done by the doctors who knew they were being videotaped. And this doctor who did this study took it further, talked about not only how if that is implemented, that quality will go up, but also raised suggestions about why isn't this being done for peer review? For if something, it's the best record that can be kept of a procedure as opposed to a doctor dictating what he or she recalls happened afterwards. Why isn't it being done to coach younger doctors to say, here's an actual video of the procedure, sit down and look at the pluses and minuses? So that study has, while it is sobering for patients who are part of the medicine where videotaping is not being used, it does lend a lot of hope for improvement in that area. And the last thing the doctor pointed out was that many of the instruments and machines being used for medical procedures already have that built in. And with data storage capabilities expanding and being more economical than ever, hopefully that's going to be a trend which can really improve medical care and cut down on errors. Another aspect where communication plays a role in medical malpractice cases is the quality of the communication between the doctor and the patient at all times, before and after there's an adverse medical outcome. So for instance, say you've got a patient who has two doctors, one who ended up pretty much assembly line treating her and made her feel like questions were not welcome. And then on the other hand, a doctor who took time to make sure that he explained everything that was going to be done, what was involved, made sure to ask multiple times, do you have any more questions, and really had a good patient-doctor relationship. Take those two doctors afterwards with the same adverse medical outcome. The one assembly line doctor is human nature. We see it all the time. We don't like confrontation. We don't like to deliver bad news. We like to think that we do our jobs well, and when something goes wrong, whether or not it's preventable, it's not something we like to have happen. Where that manifests itself is the communication can be extremely poor afterwards. That assembly line doc probably is not going to spend much, if any, time with that patient afterwards. We have patients call all the time, and one of the first questions we ask is, well, what did the doctor tell you the reason why this happened? I never got an opportunity. We kind of had an uncomfortable exchange where we really didn't talk about it. He was uncomfortable, and I was not in a right place. Then compare that to the other doctor who did all the right stuff before, who comes in, sits down, and whether it's an error or a complication, explains that, explains why it happens, says what is the nature of the injury, what's going to need to happen, is there going to have to be care involved in that care, says I'm going to end up making sure that you see this specialist and be in the loop. There's no data on this, but there's no question that between those two doctors, that first assembly line doctor likely is going to result in a call to a lawyer like me. That second doctor may not. If it is a preventable medical error and that patient and their family ends up feeling that this really shouldn't have happened, they may call. But there's going to be a number of them that say, we like this doc, and this doc tried the best. And it just goes to show that the role of communication is so important at all stages. Hopefully this discussion of medical malpractice in the healthcare industry helps to clarify some of the facts and myths about medical malpractice. There is a lot going on right now in healthcare, led by the implementation of the Affordable Care Act, and there are many ways in which it is not known now how the Affordable Care Act will play out in different aspects of healthcare and the effects it's going to have. There are other things going on that makes it difficult for doctors and hospitals to end up provide the care that they end up giving. The reimbursement rates for both hospitals and doctors, there are trends that show that those have gone down over the years, under pressure of government payor programs and insurance companies, and that has put a squeeze on hospitals and doctors. Throughout this, however, it seems that medical malpractice lawsuits are a convenient target, maybe because it's the law, lawyers, lawsuits, reports of verdicts that ended up making the headlines without fully understanding what's behind the case and what happened. But hopefully a discussion of the statistics and the role of medical malpractice lawsuits show that there is, one, it's not a significant problem in healthcare today to the system as a cost. And that second, its role is a vital one in ending up making sure that victims are compensated and providing incentive for good healthcare.